Thank you so much for joining me today.
Yeah,
this
thanks
is
for having
Mallory Moretti of Berlin Patten. She is a state-certified attorney, state of Florida, and she works with Berlin Patten, does a really good job for us, does a ton of closings. How many files are you working on right now?
Currently, I have 82 as of this morning, so it's good booming business right now.
Booming, that's right. And I heard through the grapevine that Berlin Patten did $1 billion last year.
Yeah, $1 billion in revenue, so.
Woo, that's incredible. And how many closings do you think that was? A cajillion? Is it like...
Yeah, not a fathom number. I have no idea. So we have a tremendous amount of volume, and I have to give credit to our staff and the paralegals and the closers and the processors. I mean, the closers and the processors are amazing. They help us so much. And what happens with our firm is when a contract comes in, you automatically get 3 sets of eyes on a file. So
Wow.
that file is assigned a processor, it's assigned a closer, and it's assigned an attorney.
Wow.
So the processor is instrumental in opening the contract and calendaring dates, while the closer is the quarterback of the file. They're speaking with the lender. They're communicating with all parties, and the attorney is overseeing all of that and really being the coach of the file. They are overseeing everything.
That's a great analogy.
Yeah.
So you've got the quarterback and the coach, right?
Yeah.
Nice.
I like football.
There you go. That's good. That's wonderful.
But yeah, so you're having 3 people see the contract at all times.
That's huge.
And
3 people who do a lot of this.
A lot of this, yeah. I mean, we have a high volume. And another thing with our firm, too, is we do have so many attorneys who this is their bread and butter. They do residential and commercial real estate, that if you have a question, I run over there 2 seconds, I get an answer.
That's beautiful.
And they've all been doing it for 20, 30 years. So we have a really good support team there, and everybody is working together to get the deal closed, whether it's your deal or not.
Love it. That's awesome. I love the fact that you have the volume and the one-on-one. I know we live actually in the same building, so
Yeah.
I see you regularly,
Yeah.
right? But I know that I can pick up the phone or shoot you an email, and there's always a response there. And I think that's the number one thing is we need that. You're big, but you also have that that touch of hey, familiarity and your accessibility.
Yeah, I mean, we like to preach almost insane communication is what Evan Berlin says. So luckily, I'm always on my phone. That's my one millennial thing. So I can pop over a text or an email or anything. I mean, I'm always accessible.
I can attest to this. I've seen you and your fiance at the pool on your phone on the weekend. So I know you're always working, which is awesome.
Yeah.
That's
well,
great.
That's when agents are working. So
That's right.
got to be available.
Well, that's incredible. So thank you so much for coming. I always love working with you. You've gone through the contract with us a couple of different times in our internal meetings, but I wanted to take the opportunity today, get you on camera. First of all, you're wonderful to work with. You have such a pleasant demeanor. And I think you bring up really great points on the contract. So without further ado, I think we just jump right into it, if that's okay with you.
Yeah, absolutely. That's what I'm here for.
Excellent. So let's take it from the top. We'll hit the high points of the contract.
Okay.
And along the way, you just tell me where you see people making mistakes, what's happening in the market right now, and any other questions or concerns for brokers, agents, or consumers.
Okay.
Wonderful.
Yeah. So starting at the first line of the contract, sounds pretty simple. It's just seller, buyer, but actually that's where we see a lot of common issues. So right now, the best case scenario for a agent, whether it's listing or buyer's agent, is to always pull that vesting deed. If you can
a previous deed.
A previous deed. And you can do that on the property appraiser's website. It's very user-friendly. Happy to email out how to do that for other agents as well. But that way you get the current vesting property. So
it's like a deed that was recorded before.
Prior,
you could pull it up at the appraiser's office, or they're like the recorder, right? So just Google Manatee County Recorder or Sarasota County Recorder.
Yes.
Perfect.
So a lot of times we'll see on a contract, seller says individual, and Mallory Moretti is selling this property when in fact I own it in my LLC or I own it in my trust. So if I'm signing out on the contract in an individual capacity, then technically the contract's not even enforceable.
It's void.
Yeah.
Or voidable.
Voidable.
Right? Voidable.
And more common, and we see this more often than not, and our firm is really preaching on extra contract review right now is so many DocuSign abilities right now. So it's hard from I've heard after speaking to agents to set up if it's a manager signing or as trustee or power of attorney. So you have to kind of think of that when you're drafting a contract. If you're working with a seller who says, hey, this is conveying out of my trust, you need to make sure that you're putting as trustee language or technically contracts unenforceable.
So Josh Blank, so it would be something to the tune of like Trend Realty managing member Joshua Blank.
Correct.
Okay. Or trustee or whatever that is. And then you'd sign your own, you don't sign Trend, you sign Joshua Blank manager.
Correct.
Okay.
Yeah.
So I think that I see errors with that all the time.
All the time.
Totally,
Yeah.
right?
I mean, I'd say at least 2 or 3 contracts a week I get that in.
Wow.
Obviously, that's the first thing I'm reviewing, so I'll send back the agent, hey, this is a quick addendum, let me shoot it out for you, get it on, good to go.
Okay, so you're helping with that process, getting addendums.
Yes.
Okay, the proper seller, the proper buyer.
Yeah,
Wonderful.
absolutely.
Good. Well, I mean, that's a huge tip right there.
Yeah.
People miss that all the time. From there, we go on to buyer names. So,
Buyer name, yes.
Individual, couples, spouses, husband, wife, entities. Tell me about that. What do you see there?
So the most important thing is to talk with your buyer. Say, hey, are you wanting to put this in a trust? Are you thinking of putting this in an LLC down the road? Are you going to make this your homestead property? If so, your spouse needs to be a part of this if you're getting a loan. Stuff like that. Those are the hot topics because more often than not, we get a contract and 10-day cash close and the buyer says, oh, I'm going to throw this in my LLC.
Well, now you've thrown that close off,
Yeah.
right? You
And
can't
I
do
mean,
that.
have you created the LLC? Oh, no, I'm going to do that next week. Well, no, we're not throwing a property into an LLC if it doesn't even exist yet. So
Yeah, that's impossible.
yeah,
Right.
it's just the big set expectations, be speaking with your clients, speak with me, let me know how I can help. And once we know what's going on, you can really get the process going with good expectations. Once you have good expectations, nobody's going to be as pissed off throughout a transaction.
Good. No, that's wonderful.
Yeah.
I mean, I think that's the important thing is when we get a contract to you guys, I see this time and time again, you guys are on it right away. Like, so you're looking at the contract, you're reviewing the contract, and that doesn't always happen. There's a lot of title companies that we bumped into or even attorney firms that the stuff comes out late in the game and I'm like, whoa, where was this early on, right? So I imagine you're spending a lot of your day reviewing these contracts that come over.
Yeah, and so that's exciting to me. A contract is a present to me. I'm excited that an agent has chosen
Only
to
you.
work with me.
Only
so
you would
I'm like,
love that.
This is great. This agent wants to work with me. I'm excited. I got a new client. Let's get this closed. I want to review it right off the bat. If there is an issue, let's get it figured out now. Because if you're going through a transaction, just say something contentious happens with buyer and seller. They might not want to fix that down the road. If you fix it right off the bat, you know, they're ready to get this closed, they do it right away.
That's a good point. So before we get into inspections, before we get into financing or extensions or anything that pops up, get these little details ironed out early on.
Correct.
Good. Wonderful. So I think from there we're looking at personal property, things of that nature.
Yeah, so I always want to touch base on washer and dryer because at least one closing a month, I'm at a table. I actually had this Friday. Washer and dryer was excluded from the purchase. Happened to be a brand new washer and dryer.
Now, was it specifically excluded?
Specifically, yeah. So
Okay.
1E is a section on the contract where you can put, it says this personal property is excluded.
Okay.
So it said washer and dryer excluded from the sales contract. Well, the buyer was not expecting it, so they had their own. The seller was expecting to leave it. So at walkthrough, huge issue, and they had to go pull it out and do all of this when that's the biggest thing I see is washer and dryer.
Washer and dryer regularly.
Buyers usually expect it to be left. Sellers usually take it with them. This time was flip-flopped.
Yeah, that's odd, right? To have it
Yeah,
reverse.
and so
like,
the seller was a little annoyed. She's like, it's an $800 washer and dryer. They don't want to take it with them. I said, no, they don't. So we got to get it taken out. So
Okay.
that's probably the biggest thing I see.
how often do they just yank it and say, good luck? I mean,
I think that's what ended up happening on
Wow.
that day because the seller was a little flustered, to say the least. So he's like, well, we'll just rip it out and they can deal with the rest of it. So
there you go.
Yeah.
Makes sense.
Yeah.
So personal property. What about? I see a lot of people like a couch and pillows and sofa and picture, and I'm like, let's not get. My firm, I'm always like, look, let's not get into brokering furniture.
Correct.
Because there's a separate, then you have to do like a separate sales
Bill of sale.
Bill of
and
sale.
if a lender is involved, they don't want to see
It's
that.
a nightmare, right? Yeah,
Because
so-
then they're thinking, oh, personal property taxes need to be conveyed with this. And
Yes.
again, the second a lender sees that, that's a red flag for them. And no red flags.
So one of the things I've done in the past is said something to the effect of furniture being left for seller's convenience, if that's something that needs to happen.
Yeah, that's great. That's a good tip to be giving your agents.
Good. I always tell people, like, look, the minute you negotiate the price of the home, then we start talking about couches, the same process is going to happen.
Exactly.
It's going to be brutal. So, okay, wonderful. So from there, we'll go on to escrow. Tell me about what you see going on with escrow issues.
Yeah, so right now in the contract, if that blank is left blank, it's 3 days after the effective date. So this still gets tripped up with a lot of agents. Say the date falls on a Sunday. It goes to 5 p.m. the next day. Same with legal holidays. So we had President's Day recently.
Yes.
A lot of agents were saying, oh no, escrow was due yesterday. No, if it's a legal holiday, federal holiday, 5 p.m. the next day. So say you got an effective contract today, clock starts tomorrow. So
is it business days then?
Business days. No, calendar days.
Calendar days.
Yes,
okay,
calendar
so we're
days.
talking escrow is calendar days. Inspections is calendar days. Okay.
Everything in the contract is calendar days.
Calendar days. Beautiful. So that's a great tip.
Yes.
So a lot of people get thrown off with that, like, oh, well, we went under contract Saturday. It doesn't start till Monday, when in fact,
Sunday is that first
Sunday's
day.
day one.
Yeah.
Beautiful. What do you see like currently with like people, and I'm seeing a lot of emails like wire fraud and things like that.
Yes. So wire fraud is very prevalent. We take extreme measures at our firm. So we actually have a website called Closing Lock where we don't actually email out any wire instructions. This portal does it for us.
Brilliant.
Buyers have to log into this portal. They have to create a secure login. That's how they get their wiring instructions from us. We do send them a email saying, hi, Mr. and Mrs. Buyer, you're going to be receiving an email from Closing Lock, our secure portal. You need to set up a login, do all of that. So we try to have the most extreme measures possible to be avoiding wire fraud, since it is such a prevalent issue.
I think I've seen that too. And when you guys release documents, there's always some sort of like secure type password deal. And it's like you guys are like on the cutting edge with all this stuff.
Yes, we try to be. Our partners are very cutting edge with any technology. We would like to be ahead of the game.
Wonderful. That's great. So escrow, you're seeing some people, we just had an issue recently where buyers can, I will make a quick disclaimer, buyers can lose deposits. They can do inspections and be out a little bit of money. And I think sometimes people don't understand there's risk involved. I mean, are you seeing people lose deposits, and for what reason?
Yeah. So, I mean, like you said, it's always a risk. We'll touch base on it a little bit more when we get to financing. But a deposit is a deposit. It's the good faith that you're moving forward. And if for some reason something goes awry, that deposit can be given to the seller. So if you are not hitting loan approval, if you fail to meet some other contingencies in your contract, your deposit could be at risk. If you are committing default, if you just for some reason say, hey, I don't want to close anymore, which seems ridiculous, but I've actually had that happen.
Happens quite a bit, right?
It happens quite a bit.
Yeah.
So deposit is a protected thing, and that's something at our firm too. We always want to make sure that our buyer's deposit is protected, whether it's extending loan approval deadlines, whether it's extending survey objection deadlines. We always want to make sure that that deposit is in place and it's safe.
Okay, so that's brilliant. I'll note that Trend does not hold escrow, and I think earnest money, money for proving you're being earnest in the contract, I think it should always be with an attorney. I just feel safer there. Do you feel that way as well?
I feel that way as well. Obviously, there are some brokerages that still like to hold escrow and then they give it to us a day or two prior to closing. Just from
seems like an extra step, though, doesn't it?
Yeah, it's easier when we know it's here.
Yes.
We don't have to reach out to said brokerage. Hey, do you have EMD? Can you give us a receipt for deposit? Make sure you're bringing that check to us. All of that. So to me, it's an additional step that's not really needed. But
I agree. I couldn't agree more. And liability, right? Like you guys are set up with like the auditing system for the state and all that.
Yeah, we have malpractice license. We have trust accounts, escrow accounts, any type of account that we need to have to know that account is protected. So
that's so much better than like me having to worry about that. I want to go help and train my agents buy and sell houses. I don't want to worry about things like that. So that's why it's better off in the hands of an attorney, in my humble opinion. So other than, I got to think, though, financing's got to be the number one trigger where people start disputing over escrow funds.
100%.
Okay.
Yes. So obviously, if you have a cash transaction, no financial contingencies, you move forward. One thing I do want to touch base on that I've seen an increasing amount is cash contracts when the buyers are actually getting a loan.
Okay, so let's clear that. This is brilliant. Great point. So you can put a quote unquote cash offer in and still use a loan. You want to
Correct.
touch on that? Because
Yes.
people don't understand, right?
So a lot of times when there's a hot property and there's competitive offers going, buyers will say, oh, I'm just going to throw a cash offer. I have the money if I need to. Well, then they end up getting a loan. And if it's a 30-day cash closing, but you're getting a loan, that's still a short time period for a lender.
Absolutely.
And if something goes wrong, you have no financial contingencies, no outs whatsoever.
So you could be sued for performance.
Correct. I just had this. This is a little war story. It was a 23-day closing. Lender couldn't get it together, and there was no loan approval. You can't, once you have a cash contract, you can't say, hey, let me make an addendum, bring in some loan approval contingencies. The seller's not going to sign that. In their mind, this is a cash contract.
That's why they took that offer, right?
So we had a nice seller, and she extended the contract, but I was stressing to the buyer, I said, if your lender can't get this together, and it was a super short period. It's not like the lender wasn't doing what they were doing. They were doing it as best as they possibly could.
Yeah, but 23 days is tight.
That's very tight. And especially now when rates are so low, lenders are just...
Refis are everywhere.
crazy.
We're getting clogged up big time.
Yeah, so I can't stress that enough to not do that. If you're getting a loan, just check 8B on the contract. Say you're getting, and then you have those contingencies, at least you have some protection. Because if you have a significant deposit, say it's $5,000, $10,000, $15,000, and you're in a cash contract, if you don't have a nice seller, they can say, hey, never mind, I'm going to take that deposit. You don't have your loan, move on.
Brutal, right? I mean, they could also sue for performance, right?
Correct,
like,
yeah.
I've heard stories of people like not only to keeping the deposit, but saying, now I'm going to sue you because I lost out
you're
on
not
market
closing.
time, right? Because you're not, they can kind of like try to compel you to actually buy the property,
Yeah.
right? So really dangerous there.
Dangerous.
So Mal, we're talking about the inspection period, and you're seeing people have all sorts of problems with the as-is versus the traditional contract. And with regard to as-is, I always say it's as-is, but it's as-is with right to inspect. Would you agree?
Yes, I completely agree with that. And more often than not, it leads to negotiations, which leads to seller credits. And yeah, technically the seller can come back and say, hey, this is an as-is contract. I don't have to repair anything.
Correct.
But if they want to get the deal closed, they're probably going to go back to some negotiations, perhaps give that seller credit. That's what I see more often than actually repairs being done in an as-is contract.
I think it's better just from a brokerage level to not have people making repairs, but to just actually exchange funds at close. Because let's say contractor A comes in and does the work, and then the buyer says, oh, that's not good enough. As a former flipper, I can tell you, any fix you make is, well, that wasn't the right fix, right?
Yeah.
So it's just exchanging maybe a credit at close or something like that, as opposed to making repairs, in my humble opinion, is probably a safer legal way to proceed. Would you agree?
Yeah. I'd rather throw a credit on a settlement statement than any sort of repair addendum or escrow for anything of that. Very credit friendly. It's easier. It's more simple.
Lenders can deal with it.
Lenders can deal with it.
Okay, that makes a lot of sense. So with regard to the as-is versus the standard contract, I know you have some opinions. I think I'd like to hear from you. Which contract would you use in a buyer versus seller representation position?
So I think the standard contract is way more seller friendly because you get to lock the buyer in. There's a very little out at the inspection and property maintenance level, whereas to the as-is contract is more friendly for the buyer. You get that free look. You have the default 15 days where you can decide if you like the property or not. So as a seller, they might not like the as-is contract as much because they're thinking, oh, well, who knows if this buyer will stay? They just want 15 days to kind of take their free look, see if they actually want this property.
That makes sense. So correct me if I'm wrong, in the as-is, you have an option. You can say, I'll take it as is, but here's the inspection issues. Repair them, don't. Give me a credit, don't. And then they can just walk, right?
Correct.
And with the standard contract, now, is there an opportunity? So let's say I inspect and there's a roof issue, but we've agreed to 1.5% credit. How does that play out?
So great question. If you have 1.5%, I'm not good at math, so we're just going to use $1,000.
There you go.
So if it's $1,000 repair limit and you get that inspection report, the seller then has 10 days to get their own estimates and see what those repairs are going to cost.
Okay.
If it comes back to anything more than $1,000, a couple options happen. If it comes into anything less, the seller has to pay it. So $1,000 and less, seller has to pay it, buyer stuck, seller stuck, they're moving forward.
Got it.
If it comes in over $1,000, then there's those options. The seller can either
So
say,
now are we renegotiating?
you're not negotiating per se, it's in the contract. You have these 3 options. And if one of these don't happen, then the contract can actually be canceled. So that's a huge thing that nobody really realizes in the standard contract. So
Right.
say we're at $1,001. The seller can say, hey, I will elect to pay that $1. You have to be in written notice, and then they move forward.
Okay.
Or the buyer can elect to pay that $1, written notice, move forward. So within 5 days after the last estimate, if none of that happens, seller doesn't elect in written notice, buyer doesn't elect in written notice, either party can terminate the contract. So that's
Either
a
party.
huge thing that not a lot of people pay attention to.
That's a huge
I've
issue.
only seen it in play once, and it was pretty cool. It's a little nerdy contract thing that actually happens. But yeah, if neither party is agreeing to, and again, it has to be in written notice, then within 5 days, buyer or seller can terminate the contract, written notice, buyer gets their deposit back.
Okay, so let me play out a scenario, a real world scenario. So I'm buyer, you're seller. We've agreed to $1,000. The roof repair is going to be $1,500. We don't alert each other. Now I want out. The 5 days passes. What happens? I get my money back?
Nope, you're just moving forward.
We're just moving.
So,
We're moving
just
forward.
moving forward.
I have to buy it no matter
Yep.
what, or you can sue me for performance.
So that's why the contract calendar days are so important. I can't stress that enough. If you're working with, I don't know, buyer, seller, whoever, just make sure you're calendaring those days. Working at Berlin Patten, that's the first thing we do. Our processors get a new contract. We calendar loan approval, survey objection, all of that. So
you're doing that as well. So at Trend, I do the same thing, probably on a little bit simplistic scale, but I put every single contract has a calendar event notifying, like Dave. You see a lot of emails from Dave, my compliance guy. He'll note earnest money due certain day. He'll note inspection period due every day. So I have somebody in the background doing that for every single one of my agents every time. So you guys are doing it, we're doing it. Hopefully they're not missing too much.
yeah, exactly. So.
Okay. How is Trend doing with that stuff? Are you seeing, do we miss more or less?
Oh, no. Dave is on the money.
Good.
So he's on top of everything. He's actually really good. I complimented him the other day on FHA addendums. He said, hey, you're missing the FHA addendum. And that is huge because on my initial contract review, I don't always pick up on addendums because I don't know if it's an FHA or not. And if it's not indicated on the contract, I don't know.
Sure.
So he's been pretty instrumental. He's been helping us a lot.
Well,
so.
I spent like a year training him. And so I gave him like checklist after checklist after. I'm huge on checklists and I'm huge on spreadsheets. So like a series of things happen behind the scenes that people don't know happens. And we have a checklist and a spreadsheet and all sorts of stuff that he and I are doing all day long. So we're trying to be conscientious of that and make it a little bit easier on the agents because they're running around with their hair on fire, right?
Yeah.
Okay, so we've talked about repair limits as is versus standard contract. Now let's open the can of worms. Tell me about financing.
All right. So big thing on this is loan approval. So if there is a loan involved, there's the default date of 30 days for loan approval. So we're going to use that for all of the examples moving forward just because it's easy and it's standard.
Perfect.
So the biggest takeaway that I need to stress for loan approval is you have to, as the buyer, provide notice of loan approval, whether you have it or you don't.
Sure.
So prior to the expiration of that 30 days, if it's looking like I just say I'm buyer, I'm not going to have loan approval. I can at any point provide written notice to the seller, listing agent, closing agent, whoever, just saying, I'm not going to get loan approval. Here's a cancellation letter from my lender saying the reasons why I can't obtain the loan. Then you can cancel, you get your deposit back. Obviously, the seller is probably going to give a little pushback, but if you have a pretty detailed letter from your lender saying, hey, they gave good faith, diligent effort, and they just can't get the loan, then you're going to get your deposit back and move forward. The reason why that's so important for notice is that if past the 30 days, there's a 3-day window. If the buyer never provides notice, the seller has 3 days where they can cancel the contract. So that's deemed
the 33rd
the 33rd day.
You're toast.
So if you don't provide notice of loan approval, it's deemed waive. So it's either saying, hey, I'm moving forward with the contract, whether I have the cash or I have loan approval. And if the seller doesn't hear anything from the 33rd day, they can deliver written notice, say, hey, I'm going to cancel the contract. And we hear a lot of times when I'm speaking with agents, well, why would any seller want to do that? They're moving forward towards closing. Well, if you have a backup cash offer for 20 grand more, that'd be a pretty good reason to cancel the contract.
Yeah, so offer comes in after yours, backup, more money. they're going to kill this deal,
Yeah.
take the cash, right?
Yeah, and if you're working with an agent or if the seller has representation at that point, when I do seller representations, that's the first date I'm calendaring is, hey, when's that 33rd day, just in case the buyer isn't going to deliver loan approval notice. I know if the seller wants to pull out, they can.
That's wonderful. Brilliant. Good point. I mean, you brought up a couple of like really nuanced issues within the contract that definitely are missed by even broker level people like me who've been doing it a long time. Okay, so we've gotten through escrow, we've done inspections, we've done financing. Now tell me your opinion of just any other thing that pops up on the contract that you see on a regular basis that maybe trips people up or causes issues or contention.
So I think the biggest thing that I've noticed recently is dealing with surveys and the title evidence deadline.
Okay.
So I think title evidence
this is
deadline,
really nerdy now, right?
It is. It's probably the most overlooked part of the contract now.
Yeah, sure.
So I have it here just so you guys can reference it, anybody watching. It's line 159 of the contract. It says title evidence and insurance. So that's always left blank. I've hardly ever see it filled in. And what that means is the title commitment and the survey need to be reviewed by the title evidence deadline date. And if it's blank, it's 15 days prior to closing for financing and 5 days for cash prior to closing.
So that's pretty tight.
Pretty tight, especially with more often than not these 30-day finance closings.
Right.
So more often than not, too, a buyer is not going to want to order a survey until they're out of their inspection period, which usually is 15 days. So if you're not even ordering the survey until 16, 17 days, you're past your survey objection line. We have been extending them, I'd say almost probably 40 to 50% of the contracts I've been getting in, just because it's such a huge objection window that you don't want to miss. Because if you're getting a survey back and there's a setback issue, there's a plat vacation needed, if you don't have it in time for that window, too bad.
Wow.
You don't get to go back to the seller and say, hey, my house is 4 feet into this building setback line, can you fix it? Too bad.
You're just toast.
You're accepting
buying it or you're losing your escrow.
Correct.
Okay.
So I tip for everybody, put a 1 in there. It's so overlooked. Nobody's going to even notice it. And then you give your buyer a day prior to closing. You have however many days, 29, 35.
So line 159. Okay, so 159, you put a day in there. You've bought your buyer plenty more time to in case a survey issue pops up. I love that. Beautiful. Yeah. You also see on the as is on 144, I put my brokerage fee on every contract.
Yes.
You like that?
I've
heard
that.
Some people say no. I think it's just a disclosure issue. Like, hey, I have them sign an addendum stating, hey, listen, here's our transaction fee, and I also see it buried in the contract on line. Not buried. I'm sorry. Demonstrated in the contract on line 144. So we not only put the addendum in front of them, we put them on the contract as well. And I just want that for consumers to be like, now you've got 2 examples, like, look, we're disclosing this cost. And I think that, you and I have talked about that, like some people don't do that. I think that that's the more proper way. Would you agree?
I agree. Yeah. And for example, I had a pre-sign this morning at 9 o'clock at a different brokerage, was on the listing side. They traditionally have a broker fee. So I know the brokerage, I throw it on there. And at the signing, the seller said, I didn't agree to pay this. And the listing agent wasn't there. It turned into a huge issue, called the listing agent, had them send the listing agreement over. And I printed it out, showed her, here, it says it right here. And
sure.
That issue is never going to arise with you and your agents because it's clear as day. And I know a few of them that I work with, they even go a step further and have a conversation with the buyer and just say, hey, this is on there. And I've never run into an issue with any of your agents or buyers, sellers at closing.
Yeah, I think it's almost commonplace. I mean, most brokerages are doing this now. It's a keep the lights on type of deal, especially for a 100% company. But I appreciate that feedback because you hear different people and the way they do it. And we at Trend, we always want to be as compliant as we possibly can without annoying you to death. So hopefully we're not bugging you with too many calls.
No, and I mean, same thing with setting the expectations. If right at the front you're saying, hey, there is this broker fee, they're expecting that, as opposed to being on the opposite side of that at the closing table.
Yes.
Oh, what is this? I wasn't expecting to pay that.
Yep. Junk fee after junk fee after junk fee. They feel like they're getting junk feed to death, right? Yeah. Because I think most consumers, they've never seen a settlement, or maybe it's been 5 or 10 years since they've seen one. So settlement statements just look like a computer screen of spitting out costs, right? Yeah. Currently, give me an example of what you're seeing as far as like a ballpark guess of, like, people always ask me, like, what's my closing cost? And I'm like, Okay.
Yeah.
That's like saying, what does a car cost? It could be $1 million or it could be $100, right?
Yeah. That's a very broad statement. I mean, luckily we have a title app. So the first time anybody says, hey, what are my closing costs? I get to give us a plug and say, hey, we have a title app.
Love that.
Go on there and you can kind of plug and play with your buyer or seller. But I mean, it completely depends.
It varies too much to quote,
varies
right?
too much to even quote.
That's good.
Because if there's a loan involved, I have no
everything.
idea what the lender's fees are going to be.
That's
I see
right.
some loans and lenders have crazy origination fees. Some have none. So
Yep.
so it's just
so too broad, and that's
Too
why
broad.
what I try to do is just get the consumer, the buyer or seller, with you guys, so you can do like a preemptive or a demonstrable settlement statement or closing disclosure.
Yeah.
We used to call that the HUD, right? Now we call it the closing disclosure.
The ALTA, closing
Okay,
disclosure. Yeah. But I mean, once we get a contract and we have title back, usually within 3 to 4 days, we can give a pretty good estimate of closing costs. Obviously, that's without any estoppels or the survey fee order or anything like that. But
Sure.
we have a pretty good estimate. We can get taxes right away estimated and all of that. So.
Prorated, estimated, all that good stuff. So tell me an example of like an escrow dispute or something that was contentious.
Yeah, so I actually have 2 examples. The first one was about loan approval.
Okay.
So we'll use the 30 days again. Prior to the 30 days, buyer sent over a letter from their lender saying loans approved subject to binding homeowners insurance. Super common. That's loan approval in my eyes because that happens 1 or 2 days prior to closing sometimes.
Sure.
So we're moving forward. That was, I think, the 28th day.
Okay.
29th day, I get another letter from the buyer. Loans denied. Insufficient funds. So I actually represented the seller on this transaction, so a little bit different. So I said to the buyer, no, you already have loan approval. You can't take it and then take it back. And it's
That's
a
strange.
gray area, though, because it doesn't mention that in the contract. So
Sure.
I'm running over to my litigator's office right away when anything like this arises. Luckily, very fortunate to have 2 of them right next to my office. So I said, what do we do in this situation? And they agreed with me, found some case law, and, you can't give loan approval and then take it back. So seller said, if you're not moving forward, we'll take the deposit. And the buyer said, no, my loan's denied. So we fought back and forth. It ended up being a 60-40 split. Sellers got 60, buyers got 40.
So that's somewhat amicable.
Somewhat amicable, I guess.
Nobody's happy.
Nobody was happy about it.
The sign of a great negotiation. Nobody's happy.
Yeah, nobody was happy about it. But that was one escrow dispute I had.
Okay.
So kind of different.
That's different.
Yeah, I mean,
How do you issue approval, then take it back?
take it
You
away.
Really can't.
Yeah, and I had a little extra knowledge from the buyer's agent. Happens to be a good friend of mine, even though I represented the other party. And I had spoken to the buyers too, and I think it was just they were going to end up having to take money from their stocks, and they didn't want to. I think they had I think they had a relationship with their lender, and they said, "Hey, can you give me a letter that says insufficient funds?" That's what I think was happening.
Sure.
Yeah.
Super bogus. I'm not a huge fan of listen, you have that 15-day due diligence period with these contracts. That's a long time for a free look, right?
Yeah.
To kind of monkey around like right at the 11th hour. Oh, it drives me nuts.
Yeah. And then the other one I had was actually post-closing escrow agreement. Those are always tricky, very tricky.
Yeah.
Because somebody's usually not happy. So this case,
especially if it's repairs or something, right?
I try to avoid those
Yes.
at all costs. Throw a credit on, way better. Like you were stating earlier, less liability for all parties.
Yes.
So this one was about a special assessment. So
Okay.
the condo association was having a meeting the day after closing. And the buyer wanted to know if there was going to be any special assessment. So he held back, I think it was 10 grand. If there was going to be a special assessment, we had that money, we'd give it to the buyer. If it wasn't, we'd give it back to the seller.
Makes sense.
Well, you would think it makes sense, and it, great
The
way
special
to
assessment was 20 grand,
Well,
right?
special assessment wasn't defined properly. So we pulled the statute, and the way it was defined, it read as a statute. It was for cast iron piping of the whole condo association.
Oh, boy.
That's a special assessment.
Yes.
However, the association was saying, oh, no, that's for part of the reserve fund. And so it was ridiculous. The buyer was a super cool guy and just said, whatever, I'm not going to fight about this, give it back to the seller. But I mean, stuff like that you just don't think to run into because that was a special assessment.
That's definitely a special assessment. There's no doubt about it.
Definitely a special assessment. No
Yes.
doubt about it. But it wasn't defined properly. We even pulled the HOA regulations, condo docs, all of that, rules and regs, and read their definition of special assessment to a T.
That's unbelievable.
Yeah.
So, I'm from Illinois originally, and title work is very different from different states. Illinois to Florida was a big change. And in Florida, you can use a title company or an attorney's office. So can you touch on I really see the value in this, but could you touch on the difference there?
Yeah, absolutely. So I have seen this and heard about it. Florida is a state where you can use title or an attorney. So we get people who are buyers from out of state and they say, oh, well, why would I use an attorney? Attorneys are scary.
They think they
legal
gotta pay
fees,
more.
you're going to tack on a bunch of legal fees.
Right.
Our
Which is not the truth.
Not the truth. We have our closing fee, which is super comparable to title fees.
That's right.
And you get attorney representation with that. So
it's huge.
We don't ever tack on fees of, oh, I need to draft this document for you. Oh, I'm billing you for this hour and a half that I'm speaking. You pay the closing fee, same fee that you pay at a title agency, but you get an attorney representing you the entire time.
That's huge.
So that's major. And I mean, I have a very good relationship with some title agencies and they can't draft documents. So if you have a power of attorney come up, they need to reach out to me or another attorney in Sarasota, Manatee County, saying, hey, I need you to draft this for me. Escrow agreements. They can't be drafting those. Those are all legal documents where you have to be reaching out to an attorney. And if you're closing at a title company, then they're going to charge you for reaching out to the attorney and paying those fees. So
Absolutely.
When I'm drafting a power of attorney or any sort of escrow agreement for a title company or anybody else, that's $350. So our closing fee is very comparable to that. So if you're getting that document, you're already getting the representation all in one.
So you're getting a lot of bang for your buck here.
You're
getting a ton of not just title services, but you're getting the opinion of a licensed attorney.
Correct. And if something happens to go awry in the transaction, I'm already there. I'm in the file. I know what's going on. I'm representing you. Again, at no additional cost. Whereas if something goes awry elsewhere at a title agency,
now
you don't have an attorney.
Lawyers.
You're hiring a lawyer and you're moving forward. And then lastly, and this is just me having a big heart, I care about my files, and I know everybody else does at the firm too. We have an obligation to actually close the deal and make sure it's done properly. We don't want to get sued. So title agents don't have to worry about that. They can't get sued. We have a Florida bar license hanging over us where it's kind of your moral compass. Hey, make sure everything is done right. You want your buyer to be protected and you want to be moving forward. You don't want to ever get sued.
No, right. And you have that extra layer of not just a license. You have that, but you also have the knowledge that people are litigious, right? Mm-hmm. So what the liabilities are. So that's a huge differentiation point. So, and I just love being able to ring you up and saying, hey, this seems odd to me. What do you think? And you no, that's okay. Or no, you're right. So I love the fact that there is an attorney not representing trend in the transaction, the consumer, but you're also able to help us make sure that we're doing everything above board as well.
Yeah, and we're not a stuffy law firm either. So we don't
you guys
have
are cool.
mahogany books and shelves everywhere with a lot of old furniture. We're fun and young and
absolutely.
Yeah.
And very cool and easy and accessible.
Yeah.
And that's why one of the reasons I really like working with you and Berlin Patten. You guys do a great job. You're super on top of it, very knowledgeable, and I appreciate you so much for coming out today. Is there anything you'd like to leave as just a parting thought here?
I really appreciate you getting me out of my comfort zone and getting me to speak in front of cameras today. It was super fun. I love working with all of your agents. They're all super resourceful and fun, and I've become good friends with quite a few of them. So
well, thank you so much. You're a gem, and your company does a great job. I really love working with you. Thank you so much for coming and seeing us.